house the other day in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
I swear, I just found this. I almost sat on it.
What is it? Oh my goodness! Does that mean there's going to be 48 pieces of the taillight?
Lens.
Do they know?
Yeah.
Michael Bryant. Hi, Michael Bryant.
Hi. Just to Serve TV on the air. Linda Kenney Baden, Michael Bryant. How's it going?
Do they know? Because you just came back from Canton this week, right? Where you you were there last week before. Do they know that you have pieces of the taillight? Because I can see the way that they're indicting people up there, which we're going to talk about later on, that maybe for some reason they're going to think Michael Bryant has stolen evidence.
And we have a ring camera video of him being at the scene of 34 Fairview. Yep. Who knows? Right. Take me away.
Take you away. Don't worry. You know a good defense attorney.
That's right. Okay, well, anyway, so obviously still some Karen Reed things that we might want to chat about. Would you agree with that?
Absolutely. And hello, everybody.
Hello, everybody.
Hello, everybody. Hello, Prince Lover. Hello, Debbie Blair, Maggie Reyes, Shy Gal, you're here. I think we're going to be back to you, taking you up on some of your offers. Disney Nerd, of course. Hello, everyone.
Okay, wait a second. And we have what you call some breaking news. This just handed to me. Oh, that's actually not the right document. Let me find the right document here so we can all enjoy it together. Okay, is it this one? I think it's this one. Here we go. Okay, so this in, of course, the Karen Reed case. We had a lot of things were pending, and now one thing is less pending, and this would be the decision regarding the testimony of James, not MD Crosby. He's a PhD, right? Yeah, PhD.
Right.
And as we can see, let me zoom in just a touch for everybody. As we can see, there's been a decision as to whether or not he's going to be allowed to testify. Remember, this is the neurosurgeon who knows about dog bites.
No, this is a former police officer.
This is a former police officer. Sorry,
who knows about
wrong
dog
doctor.
bites. Wrong doctor.
His is still hanging out there, right?
Yeah.
He's still hanging out
there. The neurosurgeon is Dr. Wolf. There's two Dr. Wolves in this case, by the way, so I can understand how everyone can get confused.
Of course. Yeah, one on each side, right?
Right, one on each side, right.
Okay, so let's read this, just because it's short and sweet, and we can get something out of this, okay? After hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements of, what's it again?
Dawbert Lanigan.
The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There you go. There you have it. There is an appropriate basis for his opinion in the record, and the proposed testimony principles and methods employed are reliable. The defendant's objections go to the weight of the evidence, not its admissibility. Commonwealth versus Davis, blah, blah, blah. Okay, so let's talk about this for a second. I actually don't disagree with their ultimate decision that it goes to the weight, not the admissibility. But it seems like such an interesting comparison when you look at Dr. Russell, right? Dr. Marie Russell, the defense dog bite expert.
Right.
She has to survive 2 days of, grueling cross-examination, right?
Right.
And when Judge Bev issues her decision in that case, what does she say about it?
She said it was a close call.
Close call.
Right.
Very close.
Right. She not only was she in the first trial and had cross-examination, then she has to survive a Dawbert Lanigan hearing, 2 days of grueling cross-examination, and it's a close call. And she's the one who treats dog bites, and she's the medical doctor. This man, while he has his PhD, he was a police officer, retired down to Florida, if my notes are correct. He started training dogs, and as far as anybody could be an expert in it, but you know what, with her, she was an expert talking about something as a dog bite. This, it appears that the prosecution is saying, well, he can take molds and he's really a dog bite forensic odontologist, right? That's what he was talking about. And let me tell you, Michael, I know you agree with the thing, but with the ruling here, But there's something called junk silence. Chris Fabricant talked about it at the Innocence Project because he dealt with forensic odontologists where they were in jail. Not they were in jail. They put people in jail for wrong opinions because they could say that this was a human bite, and it matched somebody who would be the murderer. The National Academy of Sciences said it wasn't good science, but all of a sudden we get to a dog, and now we can take a mold of maybe alleged Chloe, and we can maybe say that's not a dog bite, or if it is, it doesn't match Chloe, the German Shepherd. If indeed that was Chloe, even though Chloe's teeth are now probably like horse's teeth and our teeth as they get pushed around,
and really, I don't think the issue is, was it Chloe or not? Chloe, I don't think has been charged, right? I think it's, was it a dog bite or was it not? Which dog, the jury can decide whether it was Chloe or whether it wasn't. It's not really relevant.
It's such BS. Okay, I was about to curse
It's a
again.
question of whether it was dog bite versus car collision. That's
right.
That's really all that matters.
That's really issue. But when you start taking molds and suggesting that you could measure the wounds and they won't match Chloe, because that's a suggestion. We don't know if that's where he's going.
I don't either. I think there are going to be so many objections about that, and I'm still waiting for the objection. And maybe this will come through a motion in limine when those are played out, because I think they had to be filed today. They'll be argued early next week. There may be a motion in limine suggesting by the defense that they weren't allowed to take part in this experiment, this mold process.
Right.
So there was no control there by the defense. There was no reason they couldn't have been. It wasn't like it had to be. It wasn't something that had to be done immediately. They obviously set it up. I think the dog was somewhere in Vermont. So they could have easily said, "Hey, you guys want to send somebody along with us because we're going to go do this."
Yeah. After being rehomed, right? After this incident.
Poor Chloe.
And after biting apparently 2 people, we saw the issues. And the whole issue of forensic odontology with people is bad enough, but with dogs, I mean, the whole point is that, the skin moves and the skin dries out and the skin does this and the teeth move as they get old, you age. And it's just... It just, why do we need this? Why can't we just go on the real evidence on both sides?
That would be a great idea.
Wouldn't that be novel? Evidence.
Yeah. So, it'll be interesting to hear the cross-examination of this expert when they get into the things you've just talked about. And the jury's going to be weighing this testimony against Marie Russell. To me, that's an easy call. That's a slam dunk. She's a proven expert. She does the job. She's an MD. It's not a big stretch to go from what she does on a daily basis to what she's testifying about.
Yep. Yeah. And she didn't go outside her lane either. She was saying, look, it's a dog bite. I can tell it's a dog bite, or it's I can just tell you that kind of wound. So that I thought that she stayed within her parameters. She knew what she didn't know, and she wasn't going to say more. This is going to be, this is going to be like blood spatter experts who come in. They're former cops, and they testify that they're now experts because they've gone to one course certification in blood spatter. We can talk about that another time, but it gets my goat as someone who really follows forensic science and practices it in the courtroom.
Yep, and it wasn't even a close call apparently.
Nope,
there wasn't even a hearing, not even a hearing,
right,
for this PhD. When it just seems so disparate the way the experts are treated, it just makes you wonder what's going through Bev's brain. I don't understand.
Well, I'm going to be a little sexist here. Why does the male PhD get more credibility than the female medical doctor? Okay, all right. I mean, I'm sorry.
So you're cutting it up on sex lines as opposed to defense and prosecution lines.
No, I say defense and prosecution, sex lines, and everything else that goes with it. I'm just adding to it and being a little bit piqued tonight that the opinion with Dr. Marie Russell was a close call, and this was, you don't even get a Dalbert Lanigan hearing.
Yeah, apparently, and the conclusionary statements are just amazing. The evidence will assist the jury. This is an expert in dog bite wounds.
Oh, wait a second, the world is on fire. I just see this. Domino is a dog bite.
What have you
Domino is a dog bite expert. Did you hear Tubi? Even Tubi was weighing in. He was just barking on it. Tubi the poodle. Yeah, yeah. Wait, I'm a dog bite expert. You want to see? I have dog bites. I think we showed you.
Yes, we've done that. We've gone through
We've
the
done
dog
it. We've
bite,
done
our
the
personal dog bites.
dog bites. Yeah.
Yeah, I can identify a German Shepherd's canine in my chest. That bite.
Yeah,
That
yeah,
bite
I have.
wound.
Yeah, me too. And a boxer, a German Shepherd,
I had
a
a
mixed
boxer.
breed. I didn't have a boxer. A boxer
You had a
bit
boxer
me.
bite.
Yeah.
Okay,
So I mean,
so
I got dog bites all over the place.
so that's one of the many orders still hanging out there. The decisions that Judge Bev has yet to render. So we'll see. Those are going to trickle out. Maybe tomorrow we'll see a bunch more of those. Who knows? We also want to talk about a new motion filed today by the Commonwealth, right? It's not a surprise that yet another motion has been filed. This one is the motion for records from docket and Special Assistant District Attorney Robert Cosgrove. Are you familiar with Dr. Cosgrove?
He is the. Wait a second.
I'm calling him Dr. Cosgrove. I'm calling everybody doctor.
Why are you calling him?
I don't know. He's a cell phone dude. He's a
cell phone, right? He's right. But okay, well, he could be a doctor, but it doesn't say that. It says Special Assistant District Attorney. I mean, we all could be doctors given.
Well, we are doctors, you know that.
Well, you and I are. We do have a JD. We do have a doctor of
Juris Doctorate.
Yeah, Juris Doctorate. And sometimes I actually knew an attorney once who wanted to be called doctor.
You want to be called doctor?
Yeah, okay.
It does bother me a little bit that you can be almost anything else and be called a doctor if you have that PhD versus an MD, but not a JD.
Not a JD.
It seems arbitrary to me.
Yeah.
Okay, so anyway, what's this about?
Why don't you tell me?
No,
I'll tell you. I'll tell you because I'll tell you.
Digital material that more cell phones.
There are more cell phone
information.
All right. This has to do with the relation between Dr. Turtleboy, Aidan Kearney, and Karen Reed. And this is in Karen Reed's case. And what it is that with regard to the evidence in this case, apparently they want to get the search warrants for records for four additional cell phones belonging to Aidan Kearney, because they think there may be some type of conspiracy that can be shown between text messages, email messages on the cell phone calls, in terms of either covering up the crime that Karen Reed, the prosecution says committed, or a conspiracy to intimidate witnesses so that a crime cannot be proven by the prosecution. So that's what this is about in a nutshell.
And here's what's interesting. I've been scrolling around here to annoy you while you've been talking. This is the affidavit.
I wasn't even looking. I was looking at the motion.
This is the affidavit in support of the Commonwealth motion. Okay, so here's Hank
Brennan, special prosecutor.
Personal friend of mine now. So he goes into some of the details as he sees them. Let's pick up with, I think, 9.
Yeah, they're prosectors. They're getting prosectors. Maybe this is a Massachusetts thing that calls them prosectors.
Such a weird word. Let's see, there were some details about what was found at the scene, again, according to this allegation, this affidavit. Okay, let's go with 5. Canton police began to search for evidence in the immediate area around where the victim had been discovered. In the dark and through mounds of snow adjacent to the roadway, pieces of a broken cocktail-style glass and multiple areas of red that appeared to be blood were recovered in their Dixie cups, or red Solo
cups.
Subsequently, hours and days later, pieces of red and clear plastic consistent with and later reconfigured to fit within the defendant's taillight were found on the lawn and the roadway outside 34 Fairview Road. The victim's baseball hat and sneaker which was flushed to the curb under feet of snow. I don't know if that means that it was maybe the snowplow pushed it. I don't know what he means by flushed to the curb.
Right, I don't know either.
Were also recovered from Fairview Road. Additionally, pieces of red and clear plastic were recovered from the debris within the victim's clothing. Now, this was a very interesting statement that I'm not so sure was made that clear in trial number 1. But he's saying pieces of red and clear plastic were recovered from the debris within the victim's clothing. And the victim's DNA was located on the taillight housing. The defendant's Lexus SUV was seized from the defendant's parents' home, And that was on January 29th. And we took great pictures of the right rear taillight. Oh, no, that's not in it.
Sorry, I took none.
Didn't say that.
When they
The
say
defendant
so.
has challenged the Commonwealth's evidence in this case to include allegations of police misconduct, claims the Commonwealth tampered with evidence, and accusations that the Commonwealth has framed the defendant with murder. So in this affidavit, he's doing a great job of arguing his case, right?
Right, right. Well, you know what? All these papers, for all of you, let me give you some inside baseball scoop. Whenever we as lawyers file papers, we know that the papers go to the media. We may not be able to make extrajudicial statements, but anything that's filed in a legal document is fair game for the media to read in the public. So that's why this is being argued. The case is also being argued within this motion so that all this gets back out to the media over and over again. As I said, Hank Brennan's a very good attorney. I mean, he knows what he's doing.
And this dovetails with
whether you like it or not. Whether you like him or not.
This dovetails with what we're going to get into about the Turtleboy hearing from yesterday, which I attended, and then today, and the interview I did with a guy who's been treated similarly, which is unbelievable to me. And we put it out there for our members. We're going to release it wide after we show it tonight. But it's it's just a couple of minutes snippet of what this guy's gone through, and it's unbelievable when you consider what he did and what he was accused of. So let's continue on here. Number 9. As demonstrated by the search warrants generated as part of the special prosecutor's investigation, and this was into Aidan Kearney. Is it Kearney? Carney?
It's Kearney.
Carney. The E is missing. The Commonwealth alleges that beginning on or about April 17, 2023, so this is a year plus after the fact, the defendant took deliberate actions to start sharing defense theories, privileged materials, and evidence with Mr. Kearney through an out-of-state intermediary. The Commonwealth alleges that the defendant instructed the intermediary to communicate with her through the Signal messaging application, explaining that it provides secure end-to-end encryption, and instructed the intermediary to forward all information, which included witness information, home addresses, grand jury minutes, autopsy photographs, and generally every piece of evidence that the Commonwealth provided to defense counsel onto Mr. Kearney. The Commonwealth alleges the defendant would put disclaimers or directives on certain pieces of evidence, such as denoting do not share, urgent, do not publish anything from the report, and make it clear he, Mr. Kearney, didn't just get it from us, but don't show the exhibits, just read them. Please tell him not to share the title. It has Yanetti's initials in it, DRY, referring to David R. Yanetti. So they want these cell phones because they think there's going to be evidence of this collaboration and attempt to intimidate witnesses, or somehow taint the jury pool, or maybe both.
And so they want to argue. They want to argue. Therefore, there's a consciousness of guilt because they wouldn't be doing this unless she was guilty. But I say, hey, wait a second. Let's turn that around. Maybe they're doing this so that an innocent person doesn't get framed, convicted of a murder. Hello. How about that for an alternative theory?
Wow, that's a crazy idea. Every time I see now one of their affidavits, I look at who signed it or how many people signed it, because it came up in the court the other day. There was at least one affidavit filed by the Commonwealth with 3 attorneys signing it. Now, that's just, it's bad form at the very least. It's misleading, and it makes it impossible to see who's attesting. These are sworn statements. Who's attesting to what
right.
in the affidavit? Are they all attesting to every fact? Well, that seems weird. Why wouldn't you it'd be more proper to do 3 affidavits. Even if you're just cutting and pasting the whole affidavit, then you're signing it as an individual. But for whatever reason, they decided, no, this will be more fun.
You know what? Can we go back a second? Can we go back a second?
Yeah, what do you want to
look
at?
The victim's baseball bat and sneaker was flushed to the curb under feet of snow. I wonder if it was flushed to the curb by the snow blowers.
Well, that's what. By the snow blowers.
Yeah, not the snow plowers, but that the cops came and they're moving snow around.
Blower, I'll tell you that.
Well, who in this case, nothing would surprise me.
Yeah, the hat maybe, a sneaker, I don't know. That's a pretty healthy leaf blower. I'd have to check mine out. I have to do some studies on whether my leaf blower, which is a pretty good one, would blow a sneaker. So somehow they were there, and of course the prosecution's position is that he was knocked out of his sneaker, right?
Right.
And the hat, which would not be all that much force to do that, but to get knocked out of a sneaker, that's a blow. Okay, so we'll see what happens with this. This is just yet another in the line of. It's dated March 5th, but it was filed today.
Yeah.
See, it was filed today at 2:00 or so.
So what they want to do is they want to take 4 other cell phones that apparently Aidan Kearney has. Apparently, there was a taint committee, and it was only maybe 1 was analyzed, and now they have. It turns out two analyzed extraction was 2 phones. A taint team was established for 4 additional phones seized that have not yet been searched. So Mr. Kearney had 6 phones. It appears to me when I read this motion, they searched 2 of them, and now they want to search the other 4 of them. And then we did have a question from Oasis Cat on this. The out-of-state person, is that the Natalie lady? I don't know the answer to that. Do you, Michael, or anyone in our chat?
I do not know.
I do not know. And Disney Nerd also has a question. Do either of you think anything will actually come of this motion? Well, I think we can answer that when we talk about what happened in the courtroom that Michael was at all week with the Dr. Turtleboy and with the new person we're going to disclose to you that the Commonwealth is doing the same thing to, charging them with, is it witness intimidation or tampering?
Yeah, witness intimidation.
Intimidation.
I was looking through this. We've been talking about the potential motions in limine. What they might include, some of the pro forma stuff versus something more specific. This is coming up in the context of a motion in limine too.
Oh, no doubt.
And they say, they even say so.
Yeah, no doubt.
Yeah. So we'll see. That may be the best forum to hear it because of the time frame we've got.
And maybe that's why Mr. Bederow, Karen Reed asked that she be added to her defense team.
That could
because they may have had, attorneys tend to talk to each other. We're going to do this, we're going to do that, and then to defend or argue against this, and maybe even argue a motion in limine. Why you're defending against this? She wanted Mr. Bederow, who represents Aidan Kearney, Dr. Turtleboy.
Yep. So we'll see. That'll come up again. That's the latest. Let's see what time is it. Well, they should be done for today. So if they got it in today, we should have it. And this is all we've seen at this point.
That's all we've seen, right? I mean, we were checking until we went on the air. We were checking to see whether there were any new filings. We don't see it, but anything. But that doesn't mean there wasn't one at the very end of the day that
It's like the midnight judges. There's still all day tomorrow, so who knows what's going to happen tomorrow.
That's right.
Okay,
that's right.
So we really began. The plan today was to talk about this Karen Reed supporter that was treated like Turtleboy has been treated, to a slightly lesser degree, but still. And then we learned the results of the hearing from today, right? And what happened yesterday dovetails into that. So let's start with yesterday's hearing, and we can stop and start it along the way. It was only about 30 minutes total, not very long, and it's all very interesting because we get to hear a lot. I mean, I have to admit, going in, I wasn't really all that clear on the specific charges for intimidation, what the allegations were, and it is ridiculous when you hear what some of these are. Let's give you a flavor of one of them.
But Michael, before you do that, Brooklyn has a really good question before we start. The jury selection is the actual April 1st. That's when the trial starts.
That is when the trial starts. That is correct. And that's pretty universal. The first day of trial, people think it's when opening statements begin, but it's not. It's when the jury selection process begins. So if I call up a pizza joint and then tell them to deliver a pizza to you at your address, is that a witness intimidation?
Oh boy, is this what you're going to tell me? This is being charged as witnesses. Oh my goodness, let's listen because I don't think we really know this.
Let's get into this now. We'll see what it's all about.
Who are these people?
Numbers 10 and 11. Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43. Let me just update this. Mr. Kearney is present. And
There's
represented by
Aidan.
attorney.
By the way, this is the big courtroom. You know, we hear about the small courtroom, the big courtroom.
Right,
This
right.
is the big courtroom, and I don't know if you can tell depth perception wise, but it's only 2 rows. There's a row. There's front row, and that's Mrs. Kearney, and that's the back row. That's it, and it's very wide, so it holds in those rows. They're pews. They don't have separate seats. You can cram about 40 people in there.
And
So-
you're there.
Well, yeah, I was lucky to get in there. It was like one of the last 2 because I was on the air. We were talking. I said maybe I should
Right.
go, and I was one of the last 2 that got in, for better or worse. But anyway,
Timothy Bradel and Mark Bederow.
There's the
Commonwealth is
Bederow.
represented by Special Assistant
forgetting the name
District
of his
Attorney
other-
Robert Cosgrove. The matter is on for hearing on the defendant's motions to dismiss.
Cosgrove.
If the parties could please identify themselves for the record.
Morning, Your Honor. Robert Cosgrove from the Commonwealth. And I guess it's a late morning. I should have said good afternoon.
So there's the. It's weird, you know, in Massachusetts, you may remember this, LKB. The prosecution, at least in this courtroom, is right on the judge's bench. I mean, right there.
They're right in
Like-
front. Right. They're
Like
in
3
front of you.
feet,
Right.
yeah,
right.
and then everybody else trails on the play.
Right.
So
Which
Cosgrove
actually,
here-
as a defense attorney, we like that. Okay.
you like that?
Because here's why. Because usually a prosecutor, you know, they have the burden of proof. Their tables next to the jury, and they're like, you know, they're looking over at the jury all the time. If they're in front, we both have the same perspective with the
Ah.
jury, you know, and they can't get that advantage on us. As a matter of
Okay.
fact, quite frankly, sometimes we can see what they're doing, what documents they're pulling out, you know. So I liked
In-
it. We liked it.
In this courtroom over here on this side, this is where the jury sits. So just to give you perspective on
Okay.
where everybody is. And again, this is Cosgrove. He's the prosecutor.
Hello, Your Honor. Timothy Bradel on behalf of Aidan Kearney. He's here in my, to my left. And Mark Bederow for Mr. Kearney.
B-R-A-D-L-E.
Okay,
Thank you, Mr.
so I got the motion and I got the response. Why don't I do this? I've got some questions, and then I'll throw out at the beginning, and maybe both sides can answer them. Why don't I start with the defense, and then I'll go to Mr. Cosgrove. So, Mr. Canton certainly a journalist. He's a satirist. Mr. Bradel, where's the line? How far can he go to satirize things? And when does it become a crime? I asked that to Mr. Cosgrove as well to address. How does the conspiracy counts, which are 14, 15, and 16, how do they fit into this? And how is that intimidation? Are there people that are mentioned in these indictments who are non-witnesses, specifically as to counts 5 and 15? Tell me, Mr. Bradel, where you think that the motorcade, how does that fit into this? Where is the intimidation there, Mr. Cosgrove? You can obviously speak to that, but Mr. Bradel, I'll start with you.
Thank you, Your
Okay, let's frame this before they get into it. And it is a little bit harder to hear than you might think.
Okay.
The judge's first concern is where does satire, and he keeps characterizing Aidan's work, comedic, I guess, as satire. So where does satire end and where does, you know, criminal culpability begin? So that's one of the big questions he wants to know. He's also asking about specific events. Like 2 of the counts are not against potential witnesses. So how do you have a witness intimidation charge when they aren't witnesses? So that's one of the questions he has. And then he
Pretty
also,
good question.
yeah, that's a pretty good question. And they also referenced this motorcade, and that's where Aidan allegedly led a bunch of folks over to witness houses where they, you know, made themselves known. At one point, Proctor said that people were driving by and spitting on his lawn. So that's one of the counts as well as witness intimidation. I'm not sure what to think about a cop that's intimidated by somebody spitting on his lawn, but that's a different question.
Honor. You know, as usual, Judge, you cut right to the point. I appreciate that. You know, we have about 75 pages between counsel and I, and I'm happy to answer those questions. The first, where do you draw the line thing, Judge?
Yeah, where do you draw the line?
Sure.
So he's a journalist. He's got his blog. He's got the website. I'm sure he gets a lot of activity, and he's covering a case. So he's acting as a journalist. But how far can he go?
Sure.
You know, and I say this to Mr. Cosgrove maybe as well. How about Michael Moore or somebody like that, or somebody who's a satirist in some way? I was trying to bring attention to a certain thing.
Yeah, interesting. You're comparing him to Michael Moore. Look at Montevecchione says, well, I don't know about that. He just got served with a new witness intimidation charge yesterday, and we're going to talk about that. We are going to talk about that.
How far does the First Amendment go in their protections? Go right ahead, Mr. Bederow.
Thank you very much, Your Honor. Judge, it is actually a clear line. It's O'Brien v. Borowski. Okay, Judge, I know you're all over this. O'Brien says that all of these strictures that talk about speech and distress and everything else, it's limited to true threats and fighting words. O'Brien says that. Watts in the Supreme Court says that. This is just well-settled law. It's unquestionable. So it has to be true threats or fighting words when the issue is speech. And that's what we have here, we contend, is this is just Mr. Kearney's speech.
How about if he says words to the effect, I'm going to ruin your life? Is that enough?
No, it's not enough,
Okay.
because it's not a specific threat in terms of any criminal behavior. And that actually is specifically addressed in O'Brien, and it's Snyder v. Phelps, Judge, Snyder v. Phelps. That's the Westboro Baptist Church case where they picketed a dead soldier's funeral. I mean, the most repugnant stuff you can imagine, but it's inflicting emotional distress in public on a matter of public concern is protected. So, and O'Brien specifically talks about that the fear needs to be defined. It's fear of property damage or being a victim of a crime. It's not fear of being sued. It's not fear of being embarrassed. It's not Ms. McCabe in Stoughton District Court saying, is there any way you can get him to stop blogging about me, Judge Walsh? That's not the fear we're talking about.
How about calling in phony pizza riders?
Look at this dude. What's he doing?
You know, I'm glad you brought
What's
that
he
up
doing
too. There's no evidence whatsoever, and he didn't do that. Mr. Kearney did not tell people to do anything with respect to that, but more to the point of our motion here today, there's no evidence of that. You know, I don't want to sound sneaky when when I say, oh, there's no evidence of that. He didn't do it, A, and B, there's no evidence of it, and that's what we're here for, is to look at the evidence in the grand jury. There's no evidence whatsoever that he told anybody to inflict economic harm on the guy. Even if he did, which he didn't, how is that a crime? It might be something he could be civilly sued for, but it's not a crime. But the most important point on that, Judge, is that he didn't do it, and there's no evidence of it.
There's me pretending to take notes over there. I think
You
I
were
may
taking
I may have dozed off. I'm not sure.
Yeah, no, you were there. There you
That-
were,
and that
right.
Points
Camera
out
got
something
you
that we want to
perfectly.
address as well, Your Honor, is the idea that there's so much imputed derivative liability infecting these grand jury minutes. It's ridiculous. You know, it's as if the Commonwealth just basically forgot about the notion of joint venture and just wanted to attribute every bad thing that has happened to any one of these complainants to Mr. Kearney. I'll give you a ton of examples. Proctor says people drove by and spit on my lawn or whatever. That's got nothing to do with Mr. Kearney. They have no evidence. He said, hey, let's get into joint venture here for you to drive by and spit on his lawn. It's got nothing to do with Mr. Kearney. Another example that should throw out the entire case is McCabe. Jennifer McCabe says, I got an email that someone was going to rape me on my front lawn. That has nothing to do with Mr. Kearney.
Okay, so are we getting the flavor of some of these charges, right?
Yeah.
Ordering pizzas to inflict some sort of financial harm on somebody, threatening to rape somebody on their lawn, I guess via email. Not sure where the email came from. You know, you get it.
The fact that there are other people, many of whom are in this room supporting the First Amendment and supporting Mr. Kearney, that are concerned about this and that speak out, Mr. Kearney is not responsible if they cross some line. It's not his cross to bear, Your Honor. If the government wants to make a joint venture case, let them try, but they certainly haven't here. And that's the most important point, is that all of these derivative liability things, you got to throw those out the window, Your Honor. you can't use them as a basis to uphold an indictment, but also there's no evidence of it. There's no evidence that he did anything wrong. So all those derivative liability things, Judge, I hope that, I know you've looked at everything. When you look at it again, it can't apply to Mr. Kearney. It's just not within the law. It's not even.
Could we stop this at a second here?
Yep.
I'm getting a little worried, okay? Because look at our chat room here. Everyone is chatting against somebody. If somebody says something bad about a witness, are we going to get charged with witness intimidation because we're running a journalistic podcast, streaming, we're journalists, and then the prosecution can come and argue, well, somehow have infected these people, and therefore they went and said bad things against the witnesses. And it's our fault. Isn't that the argument that's going on here?
Well, this is the counter argument that defense counsel is making, is that you have to create a joint venture. You have to, which is basically a conspiracy analysis, right? There has to be a joint venture between people. You can't say what a third person did is attributed to you, the defendant, unless there's a connection of some sort, even if whatever they said was actionable. Let's assume it was actionable.
But doesn't it have to be a mens rea also? I mean, seriously?
Well, yeah, again, under a conspiracy theory or a joint venture theory, you would have a meeting of the minds to do something. You have to assume that thing is truly intimidation. That's a different issue. But you have to have a meeting of the minds to go forward with the act, and then whether the act is or isn't intimidation is the next level of analysis. And so he's saying that I don't care what these things were that were said or done, there's no connection, no meeting of the minds, no joint venture with Mr. Kearney.
Okay.
Zanetti, defense lawyers talk about Zanetti all the time, about how broad it's become. It doesn't even come in the galaxy of Zanetti. There's no evidence that Mr. Kearney urged anybody to call the pizza man and, order things and not show up. There's no evidence about the Proctor thing. He's got nothing to do with the Jennifer McCabe emails. All these things, Judge, are the government's attempt to just throw enough mud at him so that a judge who's swamped with these things says, there's all these allegations. I know you're not going to do that, and that's why we're here in front of you, is because we have every bit of faith that you're going to look at this in the way that it needs to be looked at, and that you're going to look at it on the right side of the First Amendment, Your Honor. The derivative liability stuff's got to be out the window.
Okay.
Can you refresh my memory on your next question, Your Honor?
I think I had asked a couple of questions, one of which was, where is the line, the conspiracy, which I think you talked about.
Yes.
And then the motorcade, which you talked about as well. How about the one with people who, in counts 5 and 15, who are at least, it's the same person, but are, it's intimidation of a witness. Is that person a witness?
I just don't have it in front of me, Judge, in terms of 5 and 15 is the allegation.
Elizabeth Proctor.
Elizabeth Proctor, yes. She's not a witness, but the breadth of the witness intimidation statute, Judge, does cover family members of a witness.
Okay.
So I'm not taking issue with that, but it just goes through every single one of these. It doesn't rise to the level of threats or fighting words, Your Honor.
Okay.
It's just, and the other huge issue that the Commonwealth ignores and just wants to look the other way and go after somebody out of their own self-interest, and we'll get to that later, but is this notion that political hyperbole is somehow off the table. So I'm going to rewind a little bit, and that's the Watts case. It goes back to 1969, Your Honor, when a guy who was speaking about the draft, and he said that if they put a rifle in my hands, the first person I'm going to get in my sights is the president, LBJ, Lyndon Baines Johnson. And he was prosecuted under the federal threat statute. And the Supreme Court, they laid it out very clearly. This is called political hyperbole. The context, the distance, the First Amendment aspects of it, it's political hyperbole. It's not really going to happen. It's something that a First Amendment protected speaker says to underline their point, to underscore the force, the rhetorical force of what they're saying. So that principle, Your Honor, is sort of the foundation for a lot of the case law that I cite in the brief, that we cite in the brief, and that, it's
So words to the effect of, I'm gonna destroy someone's life, or I'm not gonna let them lead a comfortable life.
Right.
That's what your argument is, that
Exactly.
even under that case.
Okay, you hear those allegations?
Right.
I'm going to ruin your life, or I'm not going to let you lead a comfortable life.
Right.
That's the thrust of two of the different counts, or one. I can't tell if they're blended, but that's the nature of the intimidation.
Which is obviously
Controlling.
different, but yeah.
Controlling, Your Honor.
That's,
I think the word you're looking for.
Yeah, well, that might be your word, but I'm saying that,
You know, it's the Supreme Court, and that's another issue we want to talk about, judges. You know, the Commonwealth of Massachusetts just forges ahead with this ridiculous statute, this witness intimidation statute. If that statute was passed in 1775, every single one of those legislators would have been pulled out of the State House and tarred and feathered on Boston Common. That statute is ridiculous, Your Honor. It talks about inflicting economic harm, inflicting emotional harm. I think someone's going to receive emotional harm if they hear speech that says, "You're a liar, I'm going to sue you." Under the statute, that's a felony in Massachusetts, not in the rest of the world, not in the rest of the country anyway.
What a shock! Massachusetts has its own little twist on things that makes it easier to allege intimidation of a witness. But I don't know.
Not under the Federal Bill of Rights in the First Amendment, but apparently in Massachusetts and in Norfolk County, it is.
Okay, let me turn to Mr. Cosgrove. I think you've answered my question.
Thank you.
Let me turn to Mr. Cosgrove. Mr. Cosgrove, maybe, so some of these counts, I mean, there's obviously a lot of counts. There's 16 of them. But going to count 8, which involved a member of the state police, where he's walking out of the courthouse here, and allegedly the defendant directs the attention of certain people towards him, and then they chant and they call him names. Does that rise to the level of intimidation?
Are you
Excuse
with
me,
me on
wait,
this?
what was this?
Are you with me?
Wait, wait a second.
So-
One of the counts is that they chant and they call state police officer names as he's going out of the courthouse, and that's witness intimidation?
One of the officers, yeah, they taunt him, and yeah. So, and the judge is questioning that, and listen to Cosgrove's response. I'll give him some
I
credit.
love this
for
judge so far,
caving
by
a
the
little
way.
bit.
I love
Yeah.
this judge.
I felt he got right to it, and he's challenging the prosecution where he needs to.
Of a witness.
I think that's probably the one closest to the line, Your Honor, candidly. But if you look at the testimony, and if you view the video, you'll see that he's pursued down the street, he's shouted, he's approached by people accompanying Mr. Kearney with cards that they're waving and so forth, and I certainly think he could have legitimately feared for his safety. The fact that he's a rather
He has a gun.
robust gentleman and that there are
A lot
other
of
police officers
security
around might mitigate that fear, but I don't think it was totally unfounded.
Okay. Well, but some of my other questions, just, as we get into these specific indictments, as to the indictments that are at the end of the 14, 15, and 16, that talk about the conspiracy with the person who evidently worked for the police department to get license plates and puts them out there. What's your theory on how that amounts to intimidation of a witness?
A conspiracy to intimidate a witness?
Yeah.
Which is a little different, as Your Honor knows, from the actual intimidation.
Yeah.
There was testimony that this person had done this sort of thing for Mr. Kearney before, that she was familiar with his online activities, and that she knew that what was likely going to happen when she turned over this license plate was that it was going to be used to dox the witness. So I think that's the essential theory. And there was also a suggestion, as I recall it, that she herself had had some interaction with Mr. Kearney in the past in connection with a niece or something like that, and didn't want to get on his bad side. And I would suggest there was a reason that she didn't want to get on his bad side.
Okay. As to some of the counts that go into the motorcade, where it goes to different people's houses with a motorcade of followers, the actions of Mr. Kearney, are you suggesting that he's acting as an individual or that he's acting in some sort of a joint venture?
Well, I think the evidence would certainly support joint venture. Essentially, there
That
was
was like a
evidence
tale
that
of poker.
Mr. Kearney
Yeah, that is quite
That's like
the
a
tale.
tale of poker.
Yeah, this is called a bad bluff.
planned this motorcade, that he broadcast what the location, the gathering point was going to be, that he showed up with a bullhorn to address the crowd, that he had his cameraman, or perhaps it was he himself with his phone to film the events for later broadcast.
Wait, stop right there.
that,
Wait, excuse me. You have your phone to film the events for later broadcast?
Yeah,
Wait,
well,
wasn't there a little case called George Floyd that the woman, the young 16-year-old who took the picture, the video of him on the ground, and she eventually won like a Pulitzer Prize for it, and she was filming it, so then the broadcast people then took it over? I mean, am I missing something
Well,
here?
I think his point is not so much that he was recording it and going to broadcast it. It's what he was doing at the time with his bullhorn. Linda, he had a bullhorn. You know how frightening those bullhorns are? Somebody is bullhorning you into testifying in a way that you might not want to. You know, that bullhorn, that tears it.
These people proceeded at his direction to the various locations. Only the first location was announced in advance, so they got there by following him. Then when he got there, he got out of the car, and statements varied somewhat from location to location, but harangued the occupants of the house.
Felony haranguing. That
Felony
is, they don't
haranguing.
mess around.
As to
So let me ask you about count two.
That was only that was only count one.
Yeah, well, the judge has been jumping around.
Okay.
But that one related to the
Proof.
motorcades that went from home to home, and
Maggie Ray says proof.
proof. No, don't worry about that. Speaking of proof, wait till we get to the end and they bring up this new charge, which is very interesting. Happened right down the street from where we were broadcasting, and the friend they mentioned was talking to me moments before they went to this bar, McCarthy's, and this evening unfolded.
It's about intimidation of a witness, 25 to 30 people. Mr. Kearney with a bullhorn telling a witness to tell the truth. How is that not free speech?
well,
So what involves name?
it's the one that involves what?
Ms. Name, Count Sugar.
Well, I don't want to sound like Bill Clinton. It depends on what the meaning of is.
all right.
But
I'm sorry. Wait.
in the
How did
context
you
of
all
Mr.
not?
Kearney
How did you all not
saying,
like start
"Tell the
laughing in the
truth."
courtroom?
There was some.
I like
snickering.
Mr. Cosgrove. I mean, Cosgrove's
Yes.
got a good reputation. I think that he's embarrassed doing this, quite frankly.
Of course he is. He's like, how did I get why? What did I do wrong? Who did I piss off
Right.
that gave me this duty? But yeah, there was some snickering. There was some chuckling, no doubt about it.
I think the witness would clearly understand that what he's instructing the witness is tell my version of the truth.
Okay. All right.
In other words, don't change your testimony or don't testify.
Okay. And then, how about releasing the phone numbers to the public? In your view, does that cross the line, taking the phone number of an officer or of a private citizen and putting that out on his website? Is that something that you think is protected speech? Obviously, Mr. Bredel does, but from your point of view, does that amount to intimidation of a witness?
I think there's a distinction between your ordinary, if there is such an ordinary thing, as putting somebody's phone number on a website and doing it to a witness in a criminal case with the intent to intimidate that witness. And I think this also relates to a comment that that Mr. Bredel made. From the defense perspective, the court is to look at this with a very limited lens. Just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said, throw a rock or show up for an exhibit, or and that's a hypothetical, or show up for an event, or here's the phone number, go ahead and call. Well, he's not responsible if what results from that are a ton of annoying phone calls, obscene phone calls, etc. But I would suggest that that's the intent, clearly, that the grand jury could find in posting that, and that's the practical result of what's being posted. And the intent further is to harass and intimidate the witness.
Okay. Anything that you want to say that you haven't said?
Michael, we have a couple questions right on this point.
So the judge has had enough at this point.
Yeah, is there metadata, Disney Nerd, for the video? Well, they want to get the cell phones, 4 more cell phones to take the information. I think that's where that's coming from. But yeah, interesting. They want metadata, and they can't give metadata on the other side. And Oasis Cat says Commonwealth and Cosgrove are mind readers now. Yeah, they have to. He just said, well, the grand jury could infer. So I guess he's not even blaming himself or the Commonwealth. He's like, well, the grand jury could infer.
Yeah, I'm just here doing their bidding.
Right.
You know, so that's the situation that the defendant has taken phone numbers of witnesses or potential witnesses and posted them, doxed them, right?
Right.
But it would take one more step to reach intimidation, and that would be somebody acting on that by picking up the phone, and so this attorney is basically having to argue that just by putting those phone numbers out there, he's incited witness intimidation, which sounds like a whole different crime to me. Witness
Right.
intimidation, and then encouraging or inciting witness intimidation, which may not even be a statutory crime. But that's what this guy's got to deal with, right?
Right.
Okay, let's see where the judge goes now. He's heard enough of this.
Mr. Cosgrove, in support of your position. I know I started off by asking questions, but if you have anything that you want to direct my attention to, or that you think is important, I'm happy to listen, and I'd offer Mr. Bredel the same opportunity. I've read everything that both of you have submitted. So let me start with Mr. Cosgrove, and I'll go to you, Mr. Chairman.
I'd just say a couple of things. First, I heard Mr. Bredel say there was no evidence of this and there was no evidence of that. And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence. When a witness testifies that I was watching a YouTube presentation and I heard Mr. Kearney urge people to order pizzas and not pay for them, that's evidence. No.
Wait, this is actually a charge.
Yeah, and
that
this
he
is
ordered people
yes.
to order
Well, you know,
pizzas
that's
from the Albert's place and not pay for them. This is really a charge?
that's a prank a lot of people pull, right? It's not exactly new, original, or inventive.
You
So
know,
there-
I have a client who got swatted up in New York State, okay? And he was at the police department because he had been doxxed all night, he and his family, on a lot of stuff, things that were private. And you know, you couldn't do anything about it. That was a serious crime. People could have been killed. People have been killed for swatting on that type of thing. This sounds ridiculous. It's you know what it sounds like? And I think The World is on Fire has it. They want the cell phones, right? And this is the way to get the cell phone of Turtleboy, to maybe get more evidence on Karen Reed and maybe charge her with some kind of intimidation. That's what this sounds like this is.
Yeah, and well, they're also out for anybody that supports Karen Reed to the degree that Turtleboy supports Karen Reed.
Right.
I mean, and you know, if that can help them against Karen Reed, great, all the better.
Grand jurors can believe it or disbelieve it. The defendant can contest it in court if that same evidence is offered in court. But the fact is, it's evidence of what happened. So I don't think the statement that there is no evidence is accurate. I think in a broader sense, Your Honor, the difference between Mr. Bredel's position on behalf of Mr. Kearney in the Commonwealth is that when you ask, where is the line?
Yeah.
Mr. Bradl's position is essentially there's no line. The Commonwealth's position is that whatever might be the case, there's two lines of cases. There's the line that Mr. Bradl is relying on here. And he suggests that to be consistent with those cases, which talk about imminent harm and which talk about threats being made to the person's face and threats of bodily injury and so forth, that this statute must be unconstitutional and that it is to be construed consistent with these civil cases that he cites. And both of the cases that he mentioned are civil cases. The Commonwealth's position is that whatever the position towards the general public, and I alluded to that earlier, the courts have said that restrictions are possible when there are reasonable limitations as to time, place, and means. And we see that in a number of ways in cases that have been approved by the courts. Cases that have recently had an approval of Judge Cannoni's order with respect to picketing in the Karen Reed case. That wasn't held as an unconstitutional violation. We have decisions in 209A orders where judges order, and I'd cite the court to the case that I didn't mention in my brief, Commonwealth versus Butler. What happened in that case, I think it's fairly well known. Your Honor may be familiar with it. Young woman on the day of her birthday went to her door and found some flowers that were anonymously delivered. I think we'd agree that if you send somebody some flowers on her birthday, that communicates typically a message. Hopefully the message it communicates is happy birthday. Unfortunately for Mr. Butler, about 3 months earlier, the court had entered a 209A order, no contact directly or indirectly. They traced the flowers back to Mr. Butler, was prosecuted, found guilty, the conviction was upheld. That sort of thing happens on 209A orders all the time, which ostensibly you could look at on their face and say, oh, this infringes on my right of association. This infringes on my right to travel. This infringes on my right to make witty, satirical statements. Nevertheless,
But Mr. Kearney is a satirist. I mean, in essence, a lot of this is satire.
well, I don't mean to be flip, but so what?
Okay. No, I mean, that's fine.
I don't think there's a special rule for satirists if the so-called satire is made with intent to intimidate.
Witness. Okay, that makes sense. Yeah, I see your argument.
I'll stop at this point.
That's fine. I'll give Mr. Bryant, I'll give you just a minute. You've made your argument pretty well, but anything else you want to say?
There are some things, Your Honor. I just invite your attention to pages 9 and 10 of my brief, Judge, where the standard of how this speech is supposed to be judged is set forth. And just a couple of quotes.
Okay, see, I definitely dozed off now. I've definitely dozed off.
No, you're writing on your notepad. I know you.
Speech on matters of public concern is at the heart of the First Amendment's protection. Speech concerning public affairs is more than self-expression. It is the essence of self-government. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. The Commonwealth is arguing the other way around. Give us the benefit of the doubt, Judge Doolin. You know, hey, evidence can be construed in different ways. Evidence needs to be linked to a particular person committing a crime. That's what they're lacking here, Judge. And this Janelle Webb conspiracy to run a license plate business, Your Honor, the Commonwealth indicted Ms. Webb and then, for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did anything with that indictment, which I've never seen in my time. And I think what happened there was that the government, the state police probably realized that, hey, they run these plates on the sly all the time for boyfriends, girlfriends, et
They're not
cetera,
supposed to run them on the
and
side.
they don't want
Yeah.
in the system a precedent where a police affiliated person, quote unquote, runs a plate and then gets indicted for a felony. And I think that's why that never saw the light of day. So there never was any conspiracy charge lodged against Ms. Webb. It's past the year presumptive speedy trial, so that case is effectively dead, Your Honor. That's an important fact the court ought to know. And also, it's not a crime to run a plate. So there was no criminal object of the conspiracy to run a plate. They just want to change, they want to erase the word conspiracy to run a plate, and let's put something in there, even though there's no evidence of it, let's put something in there that'll fly, like conspiracy to commit witness intimidation. There's no evidence whatsoever that 13B was implicated in any running of a plate. In fact, it's quite the opposite. It couldn't be more newsworthy. The district attorney had just gone on television with a remarkable statement vouching for witnesses in his case, that they were fine, they were on the up and up,
I'm
and
not
leave them
interested in
alone.
that, but in terms of, so you're under indictments 14, 15, and 16. Your argument is that there's insufficient evidence for those to actually be a crime.
There's no criminal object. And even in the grand jury, Sergeant Tully admits, and he says it's not a crime, it's an administrative violation. He says words to that effect. You'll see it. And he does refer to that, and it's not a crime. That's why they couldn't say conspiracy to run a plate, against the rules, because it's not a crime. That's why they switch it to conspiracy to intimidate a witness. It's not intimidating to prove the exact opposite of what the district attorney said publicly, that these witnesses are affiliating with the state police and do know the state police and are visiting them at their home. So it couldn't be more newsworthy, Your Honor. And that's what was behind running the plate. It was not to intimidate anybody, but to shine the light of day on corruption.
Okay.
So
And if you wanted to stop it, Michael, if you want to talk about obstruction of justice, if the district attorney or the police are saying they're not carousing with the witnesses, but they are, I mean, the investigation should be into them, into obstruction of justice, not into somebody who's trying to show that maybe they are obstructing justice as a person. But this boggles my mind so far.
Yeah, well, if you just break down each of these counts, you just wonder what the grand jury was drinking. I mean,
Well,
who's just telling them what to do? Because I don't think a normal person in the grand jury is supposedly made up of just, local folks. I can't imagine they would look at these facts as they've been laid out and say, yep, that's witness intimidation. Yep, that certainly is witness intimidation.
Yeah, but the old saying, you can indict a ham sandwich.
That
We
is
do have
correct.
some comments. And by the way, before we answer, we're going to continue on with this, but please hit that like button, subscribe, share, notify, but most importantly, hit that like button, because that gets us into the algorithm if you're watching right now, because we have a lot more to go here tonight. This is open court. A lot of these things happen in open court. You're right. Oasis Cat is in 209 related to a DV count. I think it's relating to a protective order that you can't have any contact. And those are now issued in more than just DV count. They're issued in regular court cases.
Yes, we'll see it in this case when the court finally makes its order. So not a lot left of this, but then I want to talk about what happened toward the end of this hearing when you think it's over.
About, this First Amendment issue, and, whether it's a jury question or a judge question. This is a judge question. You're not the first trial judge that, even in my practice, that has dealt with this. And I put this in my materials. You have Judge Walsh and Stoughton.
Yeah, there was two judges, right?
Right, and so Judge Walsh actually did two things, Your Honor. He did Mr. Schiffer, who's here in the courtroom today, and I appreciate it. My other client, Mr. Schiffer, is the guy that put rubber ducks all around Canton with political statements about the Reed case. And remarkably, the Canton Police Department did a 37-page investigation that was, if they applied that much work to the Reed case, those folks wouldn't even be here anymore either. But they did a 37-page investigation.
They give 37 counts with every duck that had a political statement about them being about Karen Reed and how bad their prosecution is?
Yeah.
What was it? One count per duck? Quack, quack.
That's right. And the ducks, those were the ducks that on the bottom said Colin did it, I think is what they and put on the bottom of all these rubber ducks.
Into Mr. Schiffer putting rubber ducks all around Canton. And that's the Judge Walsh opinion, and you'll see it in there. Denied on First Amendment grounds. It's not witness intimidation. Denied on, and arguably,
But there's a difference between that and saying we're going to make the life miserable, isn't there?
well, Judge, that's O'Brien v. Borowski. That's foreclosed by O'Brien. Fear of being sued, fear of being yelled at, fear of being embarrassed doesn't cut it. If I just could have one moment.
Yeah, no, take your time.
Let me mention something, the technical issue here. A couple of folks have said, boy, this camera person must have been drinking or they're having problems. Remember, this is not live. They recorded it. And when you change position from one person to the next, you want to make sure you're focused on that person. And to do that with most electronic news gathering cameras, you zoom in on them and you zoom in on their face, then you fine tune the focus, and then you come back to whatever the framing is for that shot. So that's what's going on here. Every time they change from one person to the next, the cameraman goes in to tighten his focus. He was probably, I don't know if he's drunk or not, but that's definitely something that would be done if he's not.
I love the fact he says they spent that much time investigating the
So
case.
Judge, with respect to these rubber ducks,
Yeah.
it's the exact same kind of thing
How often do you hear that in court? Now, Judge, with respect to these rubber ducks,
that Mr. Kearney's accused of doing, and it's thrown out on First Amendment grounds. It's Colin did it. It's, statements about the case. It's the same kind of thing. And, they went after him. And that's what happens when these kinds of bad statutes get used for ulterior motives by self-interested police and prosecutors.
Thank you so much. It's been a wonderful argument on both parts.
Of both parties.
Both briefs were very good as well.
Thank you.
I'll take it under advisement, and I'll have something for you soon.
Thank you.
I think it's over.
Thank you.
Your Honor.
Next seat, please.
Oh, yeah.
What's your session?
Let me just, can I talk to the lawyers at sidebar for a minute?
Okay, it's sidebar time. So
Okay.
I'm going to zoom past that, and we're going to find out what that whole sidebar was about. Let's see if I can. Come on. Help, come on. Keep going. Make sure I haven't missed it, because they haven't moved. Why are they still
It seems to me if anyone, whoever that they were talking about had the rubber ducks, if Colin Alper wanted to sue him for defamation, that's a different issue.
Yeah,
That's-
totally
yeah.
different issue. Totally. And that's civil matter. I think they may have cut out the sidebar. So let me see.
I just want to know. Then he goes on to
Okay. Yeah. So let me tell you what was going on just for the moment they were in the sidebar.
there was window of D&E
There
pizza.
was
Yes.
about a 5-minute break, maybe
Your Honor,
less. And the judge is starting to hear from the prosecution about another incident that could allegedly be witness intimidation. And he's talking about, what you're going to hear is details from the night before, when we were out broadcasting on the street right across from the waterfall, right down the street from McCarthy's.
Right.
The friend you're going to hear the prosecutor reference is a guy I now know, having been there, who stopped as we were wrapping up. And we chatted for a bit. And he said, I'm going to have dinner with Aidan down at McCarthy's. I said, great, and have a fun time. Okay, so that's the backstory for what was about to happen.
I can just take a moment. This morning I was informed that there was a incident last night. Apparently the defendant and a friend were at CF McCarthy's, which is a bar in Canton. It's next door to D&E Pizza, which is owned by one of the witnesses in this case, and his son, who is also a witness in this case, and I should say they're witnesses in the Karen Reed case, works there, and they are both victims listed within the indictments that are before your honor. At the end of the evening, the son closed up at D&E Pizza and went home. There is a video camera, possibly more than one, but one in particular in the window of D&E Pizza. And what it recorded was that Mr. Kearney left C.F. McCarthy's next door and in the company of a friend, or shortly joined by a friend, walked up, either noticed or had previously noticed the video camera, and walked up to the window quite close, pressed his face up against the window almost, and then stepped back for a moment or two. Spent a couple of minutes just staring there, and then went into a 2-minute diatribe saying hello to the witness. What have you done? I wish he was alive today. Why did you do that, Chris? He's talking to Chris Albert, the witness. I just want to know. Then he goes on to say, and I have to paraphrase from here, Your Honor, because I didn't get it all down in the brief time that I viewed it. But I know you didn't do it. Colin did it. And then he goes on essentially to ask why he is covering up for his son, assures him that he's not trying to frighten him. He just wants to know. Just wants to know. Now, at that point, he walked and went away, leaving Mr. Albert to find that the next morning when he reviewed his video. Now, we can talk about how many legal angels dance on the head of a pin here, Your Honor. I think I could do Mr. Bradle's argument for him. It's just speech. Nothing's meant by it. It's protected. I doubt I've saved him the trouble, but I've tried. At this point, I don't think it's an issue whether technically it meets the standards of intimidating a witness. I think certainly the attempt, at least in the colloquial sense, was to harass and intimidate. And we always talk about these in isolation, Your Honor, but there is a drumbeat every week of verbal attack after verbal attack on the witnesses and the officers in this case. So at this point, I am going to ask the court to set bail on Mr. Kearney. He's been released on his personal recognizance. And I am also going to ask the court to set conditions. And those conditions will be no contact, direct or indirect, or through third parties. And I mean no contact in the broadest possible way with any of the witnesses or officers testified for the Commonwealth in the Reed case, or any of the alleged victims in this case. And I am going to ask that Mr. Kearney, as a condition of his release, be prohibited from approaching anywhere within 100 yards of a victim's residence or within 100 yards of a victim's place of work.
Okay, thank you. Mr. Bradle.
Thank you very much, Judge. Judge, this is not how incursions of someone's liberty are done in Superior Court or in any court that I know of in the Commonwealth of Massachusetts. I don't have a shred of paper. I don't have a shred of documentation. I don't have anything on this issue.
You want to continue? I'll give you one.
Yes,
I mean,
certainly.
you gotta look at it.
Yes,
You
absolutely.
want to come back tomorrow?
I don't think I can come back tomorrow, Your Honor, but you know, the government should be sent out to go get their ducks in a row, no pun intended. And
Maybe we
Then
could
if
borrow
they have-
Mr. Kearney's.
if they have an issue, then they should come back for it. But you don't say, hey, I heard this thing happened and
Why
I
don't
want
I
to.
do this? Why don't I do this? I'll give you 24 hours, Mr. Bradle. You absolutely have a right to review the video, and you have a right to see any reports that were written. I'll see you both back here at 2 o'clock tomorrow. Does that work, Martin?
I was gonna suggest noon.
How about noon tomorrow? Does that work for the both of you?
That's fine, Your Honor, and I don't mean to prolong this unduly, but I just want to say I became aware of this incident that happened last night at 10 o'clock this morning.
That's fine. Okay.
So,
And that's great, but the government should do some investigation
that's
and,
fine.
give
Hold
me
on.
a chance to say
Yeah,
something.
we'll address it tomorrow at noon. In the meantime, Mr. Kearney, just stand up, stay away from that pizza place, okay? What was the name of it?
I'm sorry, Your Honor, it's D&E Pizza.
Okay, just stay away from that, and then we'll address it tomorrow, okay? All right.
So, the matter is continued to March.
All right. So
So wait a second. If somebody went with him, and we're going to hear that person, right? Because you did it near you.
no, we're not going to hear that person, but I can tell you a little more about what that person did that night.
Yeah. But if you say, I know you didn't do it, it seems to me that at the most that could possibly be a civil harassment, that could possibly be defamation, but I don't see how it's intimidation in the legal sense. I mean, I'm at a loss here.
Yep. So,
Right, right.
and there's, let me read you a little more about what was said into the camera that night. And again, I spoke to the friend after the fact,
Right.
and he described the actions that took place. They're both leaving together, McCarthy's, and I would guess that there had been some alcohol consumed. I'm not 100% sure, but it sounded like the friend was sort of arm in arm with Turtleboy, and was sort of supporting him right there with him when he was performing for this camera. So that's the picture that I was given. And here's what he said. This is a more complete quote. "Hi, Chris. What have you done? Murdered. Misses you." Again, it sounds like some slurring of the words. It's a little sketchy. "Wishes he was alive today. He would be. Why did you do that, Chris? Chris, why did you tell the jury that you got home? Why did you say you went upstairs and then waited 15 minutes? Then Colin came home. Colin didn't make it home until at least 12:45, Chris. It was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you." So that was,
That doesn't sound like anything form of intimidation.
no, it just sounds like guys pissed off and accusing somebody of something, but okay. If he had said in here something like, if you don't testify truthfully, I'm going to burn down your pizza place. At least you're getting something. At least that's close, right?
Right, yeah.
So anyway, so let's follow up with what
Okay.
happened today, because they went back to court today, and that last count, which would now be count number 17, is still somewhat in limbo. The judge did not dismiss it out of hand because it hadn't been properly brought. So it still exists in some form, and it's still going to have to be addressed. But it wasn't dismissed, and there's been no ruling from our most recent check on those original 16 counts. Some of them, we heard how flimsy they sound, but at this point, those have not been dismissed either by the court. So,
And it sounds like the Commonwealth really wanted to bring this, not because of the witnesses, but because they want to get his cell phone. But
well, that's certainly, I think that might be a benefit. I really think they're after him, period.
No,
And
they're
maybe
after
getting
him,
the cell
right.
phones, that's a nice extra benefit. So
Yeah.
should we talk about the
Yeah,
guy
just
I interviewed, Keith?
before you do that, let's just answer a couple of questions. Montevecchione, I never understood why they chose witness intimidation instead of harassment or something like that, just for the felony charge. Well, obviously, we had a lot of issues here. You're absolutely right. And then this one, Michael looked really engaged back there. What were you really thinking back there real time? I guess you're going to tell us. And there are stalkers who are dangerous, and the police do nothing. Absolutely right. We hear about how many women get killed by, their ex-husbands or their boyfriends, and the police do nothing. I mean, this is. I think that everyone brings their own knowledge into this, right?
Yep.
Yeah, I look a little blurry, Prince Lover, because we're having some kind of reflection on my set here tonight, and we've discussed that in terms of the tail light. Even you can even see when I raise my hand. See, I'm getting a
You
reflection.
got some weird, wacky ghosts going on there.
Yeah. It's who knows? Yeah. Okay, so let's talk about this because you were there. Now I'm concerned that you're a witness.
No, I was not there. I mean, I was down the street across from the waterfall, and I interacted with the friend spoken about in court that day. And then I talked to him after this hearing. I said, "Well, nice work. What exactly happened there?" And that's what he told me what he did. I would not identify the guy. He can identify himself if he wants, but the court did not, and I'm not going to. So,
But
yeah,
didn't you run some kind of video about this
no,
on our members only page, or no?
no, this is a video of another guy, and when we hear his story, you can square it up against what we just heard about Turtleboy. This guy Keith, who we're going to play right now,
Which is not the guy with Turtleboy last night.
no,
Okay.
no, totally unrelated, except in that the way he's been treated by the Canton's finest or the Massachusetts police will sound somewhat familiar. So let's watch this, and we can talk about that.
Okay, now let's before you play, this has only been seen by our members. No one else has seen it. This is the first time anyone is going to see this here right
Yeah,
now.
and then we'll toggle it to a public if anyone wants to watch it again. Okay, I'm here with Keith. Keith has an interesting story related to the Karen Reed shenanigans, extravaganza. So, I see all you guys out there every time I'm here. There's a big presence, Free Karen Reed. In fact, I can see it right there, the Free Turtleboy, which we know Aidan had a hearing today. So tell me about the experience you had that's similar, really, in ways to Aidan.
We were standing in front of Walgreens, and probably had Free Karen Reed signs. There was 9 of us out there, and the police showed up in full tactical gear with facial recognition cameras, and they tried to charge us with felony witness intimidation. And we had to go to court, and we had a magistrate hearing, and they made us wait almost 9 months before they decided to drop the charges. And afterwards, our fearless police chief is still trying to get the Mass Supreme Judicial Court to reverse the magistrate's hearing.
And reinstate charges?
We will if she gets them to do that, but I don't feel they've never done that. She's just searching. She's
Seems like a
trying to
lot of
take the
effort.
heat off
Yeah,
herself.
it seems like a lot of time and effort,
Yeah, for
taxpayer
nothing.
money.
Yeah.
So when did you hear that you were no longer charged, that they were dismissed?
August 24,
And this happened when? When was the event?
November 5th, 2023.
And so you were just twisting in that
just
period of
hanging
time.
there waiting.
Did you have to hire an attorney?
Yes.
So it cost
All
you money.
9 of us. Well, luckily some people donated and it covered the cost, and then everything that was left over went to Karen Reed's defense fund.
Yeah. So stressful though?
It was stressful.
Yeah.
Couldn't make any plans, couldn't do anything, didn't know what was going to happen.
But it hasn't deterred you, obviously. You're still out here.
Yeah, still here. It's the right thing to do. It could have been any one of us. Karen could be any one of us. So you do what you got to do.
So there you go, Keith. I mean, just imagine. I'm just hanging out in front of Walgreens, and protesting, peacefully with signage.
Holding a sign, yeah,
that just
holding
says-
a sign, Justice Serve TV.
Yes, yeah, Free Karen Reed, and he gets arrested. He and 8 others, as Nancy says, they called them the Canton 9.
For
And
witness
there is
intimidation.
and
For
what's-
witness
yeah,
intimidation.
felony, just like Turtleboy. And even now, they've taken this up on a writ to try to reinstate the charges. So that's still kind of hanging over their head.
I think we should talk about this even more. I mean, if there is a pattern of the police department charging people for First Amendment protesting in favor of Karen Reed, that's outrageous. That's another whole story. Nancy says one of those 9 charged was a 17-year-old high school wrestling star. That is horrible. That is horrible. Horrible. I can't believe it. I mean, I honestly have no words, Michael, on this. I hadn't seen that interview. You told me about it. I hadn't seen it.
Yeah, it's so outrageous because you have to start wondering, what else will they do? How far will they go? If in fact this is all motivated by, I don't know, justice for a former cop, but if justice means putting it on somebody that maybe you don't have the evidence to prove is the actual defendant, how far will you go?
Yeah, it's at the very least, it's disturbing. At the most, it's sinister. Not even the most. At the second most, it's sinister. And at the final part, it could be a crime, in my opinion, because then what you're trying to do is you're trying to shut down anyone who's looking into anything about Karen Reed. What will they do against the attorneys? What will they do against the attorneys? You
Yeah,
know?
well, if they're smart enough, they won't go there. You know, they're trying to pick on people that they think are really unable to fend for themselves. Luckily, they've had a lot of support, both monetarily and otherwise, where people have stepped in, just like with Turtleboy. He's got plenty of support.
Yeah, but you never forget being arrested, okay? Especially if you're 17 years old. I mean, you're
Mhm.
still arrested. I mean,
And it's a
you
felony
know,
charge.
and it's a felony charge, and then it has to be taken off your record. And then you got to wonder, anytime you do anything else, am I going to get charged? Is somebody going to see that I was arrested once? I mean,
Yeah, and
this
it
is
comes up, it
serious.
comes up, job employment, and it comes up in a vacuum. It'll just come up as, a charge, even if it shows dismissed, right?
Right.
You got some splaining to do then, and it just puts you in an awkward position.
Yeah, jobs, everything, everything. I mean, I hadn't seen that. I am truly disturbed by that. I'm disturbed by some of the things you said before, that you can be charged by telling someone to tell the truth, and
Yeah.
that all of a sudden you can be charged for witness intimidation. And I don't think I think the public is really focused on Karen Reed. I don't think they've been focused on this. I mean, you're
Well, that's
focusing on us now because you were there.
that's why so many people, when I talk to them, were saying, yes, Karen Reed is one of the symptoms, but this whole system is out of whack, and they all have their personal stories about why they think that. Whether it's the Sandra Birchmore crossover, whether it's going as far back as the archdiocese, with all of the preachers and the priests. They just think this whole area is so corrupt that they want to take a stand against it. And the Karen Reed case just happens to be, front and center.
Yeah, no, it just it's disturbing. It's horrible, and I'm very happy that he spoke to you and that you were able to get into that courtroom and listen, as I was anchoring out here for what was happening inside the Karen Reed courtroom. And so, boy, I'll tell you what. Next, they're going to go after people like us, who have our
Yeah.
people who watch, who have opinions about this case. Interesting. Oh, wow. Nancy says, I live in Norfolk County, which is where Dedham is. I think I said Norwalk yesterday, or thinking about where you are, in Connecticut. And recently got a dash cam. The police can't be trusted around here. Of course, if they come to arrest you, they take your dash cam unless it's loaded immediately into the cloud.
Well,
you know
what? There's so many videos out there of, cops being recorded by drivers, and
Right.
it's frightening how often it happens that they're abused. And I mean, just misrepresenting what the law is, asking them to do things that they don't have the right to ask a person to do unless they're under arrest.
Right.
That's so what am I arrested for? What am I stopped for? What am I, just suspicious? Well, suspicion is not a crime.
Yeah.
And so,
the thing about
it's
it is
abuse.
there's so many good cops, right? We know them.
Of
There's
course.
so many wonderful cops. It's such a hard job, and then
Yep.
you focus on something like this, and then it becomes it puts a taint. It's just like when there's a bad lawyer.
It's the George Floyd syndrome. It's the small number, but man, it makes an impression.
Boy, doesn't it? So I have to ask you all watching a couple things. Share. That Keith video is gonna go up now on our public website, on our site publicly.
Yep.
Okay. When it goes up, hopefully, if you have liked and subscribed, you'll get notification that it's gone up, and you can share that. I think that should be shared, because what we just heard today regarding Dr. Turtleboy and the other person who's yet to be named for being with him as he's talking into a pizza parlor cameraman of one of the witnesses is truly something. Yes, it sounds something is not, as we used to say, copacetic in my family.
My dad used to say that word.
Yeah, not copacetic. But anyhow, if you do that, please hit the like button, and if you would, get us into that algorithm. If you're watching right now, the subscribe button.
It is now out there, I think.
It is now out there. Okay, so if you go to Justice Served TV YouTube site, and Missy, of course, will be tweeting it out there about Keith and all that, because it truly is disturbing. And also, when you're looking at the show, I mean, obviously we have a segment on Turtleboy, we have a segment on Karen Reed. We'll try to separate those out tomorrow, so you'll have them. And then tomorrow night we'll be on again, I think about 6 o'clock, to answer more questions that have been asked of us. And maybe we'll have a double show tomorrow, depending on whether there's a ruling on that motion to dismiss that was filed. If not, we won't until that happens. I'm beginning to think that maybe it's more like Monday, or maybe the end of the day tomorrow. She puts it in, so they have the weekend to deal with it and all. And then the motions in limine get ruled on Monday that she's going to deal with. I don't know. We're so close to the trial date of picking a jury that it gets hard. But anyhow, hit that like button. And I know you have some words of wisdom.
Oh, yes. Is that my cue?
I think so.
Yes. I'm Michael Bryant. Hey, thank you for joining us. Try to do the right thing. We'll see you next time.
And I'm Linda Kenney Baden. Together, Michael and I are Justice Served TV. If you like us, hit that like button again, subscribe, share, and the notify all, so you'll get notification when there's a new episode, and we will see you tomorrow.